It's the SKADI, it's the Alexandra claps, the trademark. Right, we're underway. It's fantastic. So, we're here after the bank holiday weekend. Everyone's looking fresh as a daisy, which is great. And we are returning, as promised, to the subject, DT, of Frasers Group versus Morgan Stanley, because we said we would get back to this subject when everything was sorted out in the courts, and we'd peel over the findings and the results and talk to everyone about it.
And funnily enough, there weren't many because it all was sort of settled pre. Well, I actually don't exactly know. I don't know, Robin. I don't know what the exact terminology is.
You've let the cat out of the bag. We've gone out for outside help because Robin Henry from Collyer Bristow, a friend of the show, definite friend of the show, has come back. Few people come back to the podcast, but Robin has to help us pick through what happened. So, Robin, really welcome back. Really glad you're here.
Thank you very much for inviting me back. I'm delighted to be here.
Yeah, it's great. Now, I noticed that we actually released the first episode on the 14th of February, which is quite poignant for a dispute, I think. Anyway, I think we should push on. And Robin, I think you are really going to be our guide on this because, there's so much Damian and I spoke about last time, and we kind of used our sort of experience to kind of say what we thought had happened, around the margin call and all that kind of stuff. Now we really want to know what happened around the case.
Yeah, no, I listened to your podcast, and it was really interesting to explain what was going on in terms of the trades and what the motivation of the various participants was. So, yes, hopefully I can bring a little bit of light, though obviously not the answers to all the questions, because Mike Ashley withdrew his claim against Morgan Stanley immediately after the trial had finished, but before the judge had given judgment. So we don't actually know who would have won or lost. But we could, give some indications of what might have been the result, or at least I can give my view, which is only my view, but it just drawing on how how Mike Ashley and Frasers Group had constructed their case and who they were bringing the claims against.
I think that sounds really reasonable and really helpful, actually, because I think the listeners would love to have that insight. So thank you for providing that. So where do you want to take us? How do you want to handle this?
Well, I think I'll set out the claims that Frasers Group have made against Morgan Stanley. We can, please, chip in and ask questions as we go along. But I think I'm afraid it's going to get a little bit technical, hopefully not too much. But some of those are sort of interesting, I think.
I think you're okay because you're here with me and Damian, so I think we won't let that happen.
Okay. So the first sort of important question to ask is Frasers Group, they brought the claim. Who did they bring a claim against? Was Morgan Stanley. But their contract was with Saxo Bank. They had, agreed these options with Saxo Bank, and Morgan Stanley had their own separate contract with Saxo. But Morgan Stanley did not have a contract with Frasers Group at all. So Frasers Group could have brought a claim against Saxo themselves for breach of contract. I think there's an indication that they may have settled such a claim. Anyway, they didn't continue that claim, and they carried on only against Morgan Stanley. So why were they concentrating on Morgan Stanley? And again, I'm not sure. I think there is one possible reason is that if they had only had a breach of contract claim against Saxo, that would have been subject to Danish law, and so they may not have got very far with it, certainly not in England. It allowed, I think, bringing these claims against Morgan Stanley allowed Frasers Group to obtain or seek and obtain an injunction against Morgan Stanley. And their main argument was with Morgan Stanley because, from their point of view, Morgan Stanley was trying to close down those trades. And so what they wanted to do, and I think this was quite a clever move, if a high-risk one, was to get this injunction, freeze everything to allow them to actually move those positions off and kind of save the position or the majority of the position for Frasers Group.
So just
go on, dive in deep.
So I'm no expert on it. Even what I mean, I think I understand what an injunction is, but that would mean, for instance, that the cash call that was being, there was $1 billion being asked for. The courts would therefore go, look, that we've got to stop this. That payment cannot be made.
It's effectively frozen.
Right.
It freezes the position.
Even though theoretically that the volatility of the stock underlying it could start to continue on moving, and someone could go, hold on a minute. There's there's a bit of pain being felt here by Saxo, by Morgan Stanley.
That's why there's a risk. That's why it's high. It's a high risk strategy by Frasers Group, because yes, they get the injunction. It freezes the position. But as you say, in order to get that injunction, they will have had to have given an undertaking to indemnify the other parties, Morgan Stanley in this case, to if they had suffered losses as a result of the injunction, i.e. they haven't got the margin call, they haven't got the $1 billion, they suffer that's huge loss in the meantime. It's Frasers Group who would be held liable for that. So it was a risky thing to do, depending on how much risk you think there was.
Just dealing with the risk, how public is that to parties outside of Morgan Stanley, Saxo, Frasers, i.e. the other market counterparties? Can they see that this injunction has happened, or is it a private? Was it private between the parties?
Usually, quite often injunctions can be obtained what's called ex parte, which means you don't have the other party there. So as long as you satisfy the criteria for getting the injunction, you may be able to persuade a judge to do so even without the other party being there, which is why you have to agree to this undertaking that you're going to be responsible if the other party doesn't suffer. So effectively what it does is that freezes the situation until there is a trial of the proper issue, which is what then came up in April with the trial of the issue. So for those 3-4 months, people have known there's been an injunction, but it just was done. It may well have been done without Morgan Stanley being involved in that process.
Okay, understand. So how and maybe this is beyond scope, but let's have a look. So if you have a situation like that where, let's say, Morgan Stanley wasn't involved, how would the court determine that the undertakings being asked for and offered were sufficient?
Well, that is would be a chance of convenience lies between the parties. Is it more important that Frasers say, because they're saying to the court, you've got to stop this margin call because this is causing massive damage to us? So there's on that side, and then there's on the other side was the risk that the trades could go in the opposite direction and cause Morgan Stanley and Saxo loss. So I don't know how the court judge it in this particular case, but it will weigh up those different factors. And one of the issues will be, well, can Frasers provide necessary security for that?
But if you think about it, as part of when the margin call came, I think Frasers publicly said, we will pledge Mike Ashley's holding plus some sterling amount, something else. I can't even remember what it was now. Sorry.
Yeah, I can. You're right.
Which added
100 million sterling.
Yeah. So maybe he's sort of gone, well, actually, if I not pledge that to the court, but if I use that as the sort of collateral, as it were, that would allow me to be able to put forward this injunction and it to be successful, that maybe, in his view, was mitigating the risk that was there.
Okay.
So if I go back to the claims that Frasers are making against Morgan Stanley, so it hasn't got this contract with Morgan Stanley, so it has to say that Morgan Stanley's committed torts, and there are specific torts that they accused it of. One is inducing a breach of contract, and the other is causing damage by unlawful means or loss by unlawful means.
TT, who's going to ask?
This is for you.
Robin, come on. What's a tort? Before we even get into that, come on, what's a tort?
A tort is where it is a civil legal wrong that is committed. Tort means French. It's French for wrong. That's where we get the word.
Oh, it was French for tart.
A legal wrong committed by one person against another where there is no contract. So negligence is one thing, or if you I mean, there's also there are various different torts, negligence being the most common, I would say. So professional negligence, you don't necessarily have to have a contract between someone, but they're in such proximity that one person owes the other person a duty of care, and they're in breach of that duty, and therefore there is, they've caused loss and they're responsible for that. And there's very specific sort of categories of that. And there's two that Frasers Group tried to use. One is inducing a breach of contract, which says, in this case, that if Frasers could show that Morgan Stanley had induced Saxo to breach its contract with Frasers Group, then Morgan Stanley would be liable for the loss suffered by Frasers Group as a result. So,
and in that, it doesn't matter whether Morgan Stanley know that there's a contract between Saxo and Frasers, or indeed what the contents of that contract might be, or do some of those things matter?
Yes, they do matter. So Morgan Stanley, to be liable, they would have to know that there was a contract between Saxo and, let's say, somebody else, and they would have to know that whatever Morgan Stanley were doing, i.e. issuing the margin call, would have the effect of forcing Saxo to breach its contract. So at least it would have to know that it's got a contract which is very likely to be broken if Saxo then mirrors the margin call onto Frasers Group. And so Frasers referred to, what is that breach of contract going to be? It's going to be the best execution duty in the contract with Saxo, a duty to act in good faith, which there is because it's a Danish contract and therefore easier to show than English law, and market practice, that in a situation like this, it had been agreed between Saxo and Frasers that no such margin call would be necessary, wouldn't be required. So this is where, but you do have to show that Morgan Stanley intended to cause Frasers the loss. And this is why the identity, whether or not Morgan Stanley knew the identity of Frasers at the time that they issued the margin call right at the start, that's why that becomes so important.
Brilliant.
Right.
Yeah, that's fascinating.
So that's one thing. And then the second tort that Frasers were trying to rely on is something called causing loss by unlawful means. Now, it's kind of a similar idea. But the unlawful means in this case is not the breach of contract between Saxo and Frasers, but a breach by Morgan Stanley of its contract with Saxo. So that's an unlawful means just means something that's technically, it can be as much as just a breach of contract. And what Frasers said was the contract between Saxo and Morgan Stanley had broken because it had these implied terms. One, that its discretion to impose a margin call would not be done irrationally. And secondly, that the power to charge the margin would be exercised in good faith. Now, that's introducing some new elements which are quite difficult to show because, first of all, you've got to show that the formula that Morgan Stanley used to calculate the margin, which was, what's it called, the jump to health stress test,
the
400% rise in Boss shares, that was irrational. It was they didn't believe in it, and it didn't reflect any sort of reality at all. And Morgan Stanley's counter that and say, well, it's an objective test. We're perfectly entitled to it. The remote, risk might be remote, but it's our risk, and we don't want it. So there's that, and then the second one, which is the exercising it in good faith. Now that's again difficult under English law because if you don't actually say there's good faith in a contract under English law, you have to imply it, and the only contracts that it can be implied into are what are called relational contracts, and there's a big long list of factors that go into whether a contract is relational or not. And it was probably quite recently those factors were set out in a case called Bates against the Post Office, which you may have heard of.
Yes.
That one. Which is the contract between the Post Office and its sub-postmasters, Mr. Bates. And so it's got things like it's a long-term contract that the parties intend their roles to be performed with integrity. They have a high degree of trust and confidence in each other. It's a very close and long-lasting contract. Is that a contract between Morgan Stanley and Saxo? That's the question the court would have had to decide. So basically, the way that because they had Frasers Group were having to say we're relying on these tortious claims. We've got all these bits and pieces that we have to show, and the other thing they have to show in that tort is that they intended to cause Frasers Group loss. Now, then you get into difficult questions of, well, what does that mean? Does that mean that they wanted to de-risk their position and as a byproduct that would have hurt Mike Ashley? Is that sufficient? They also brought up the allegation that Morgan Stanley did it in order to create a disorderly wind down and then they would profit from their trades because there'll be a great glut of shares on the market. Those are questions which I don't think, we don't know the answer to, because that would have had to have been decided by the judge after the trial. But I think I'm not surprised in a way that Mike Ashley withdrew the claim, because there were quite a lot of legal hurdles for him to get over. I mean, if you look at, was the margin call irrational? Given that there were no boundaries for what the margin call could be, then to me it doesn't seem like it's irrational. It may be unlikely or unreasonable from Frasers Group point of view, but it doesn't seem like it's irrational.
Well, I think this is one of the interesting points, because, from my memory of what we read, there wasn't a policy inside Morgan Stanley, and there was a lot of scrabbling around to actually evidence how they'd arrived at the margin call. So that it wasn't really the case that there is a kind of applied, set of parameters that they would employ. And that, I think, made things observationally harder, probably, for Morgan Stanley in this situation, because you're kind of pushing against something. And I think what people need, if you think about, you can always say, well, you can set up terms and you can agree that this is what would happen. Really, what you need to do is, in a big organization like a bank handling contracts, which has, operational needs, you need to make things as smooth flowing as possible with as few, manual touch points as you can. You don't want, your operational staff having to go in contract by contract and analyze what was agreed at the time. That's why policies are powerful, because they help, enhance understanding. Everyone knows where they stand. I think it is an interesting situation in this one particularly, that there didn't appear to be a policy at the time, which made it a lot harder. I mean,
for me, you think if I was advising Frasers Group and you're going to enter into these option contracts, and I know there's a prime broker in the back of it, you'd say, well, let's set some limits in the contract on how much margin call you can put. Can call, but maybe that's not possible. Maybe that you'll just never get a contract. Maybe it's in the marketplace. That's not something that.
I think there's also the interesting,
or maybe following this, it might change.
Well, it might change, but I think also it's a good point, Robin, because what's wonderful about this case is it lets everyone look at a real situation, and the real situation here wasn't that. Frasers had this position naked, Damian, was it?
No.
Effectively it was covered. They could, provide stock, they could provide guarantees. And that's very real world, right? There's all sorts of different parties in a marketplace with different motivations and different ways of executing, their positions. And that's what makes, disputes interesting, but also difficult, because you've got to, the court has got to come up with some kind of fair decision, particularly when you have kind of multi-party cases where people have come at things, they're all disputing the same thing, but they've come at things with different positions, hedged, unhedged, and so on. So that's an interesting one, because in this case, actually, I can always see because they could have covered it. I can always see that actually there would be a case for Frasers saying, actually, do you know what, your policy wouldn't apply to us. We'd agree different terms because we're good for it.
Yeah.
You're not under any risk.
Yeah, but the contract obviously wasn't, straight through.
But
so
that's true.
Part of the issue. So they could go, well, in their view, Morgan Stanley's view, that it's a naked call position. And even if, they phone Saxo and Saxo go, well, actually, the underlying client who we don't want to disclose, maybe for whatever reason, has the underlying, they go, well, that's, you can't prove that. So, we're happy to make the call, as it were. But yeah, it brings up stuff about, as you say, about collateral that sits underneath, agreements within stuff, and if it has to be delivered or called or whatever, along those.
And so what Morgan Stanley then said is, so we didn't know it was Frasers Group, or the risk officers didn't know it was Frasers Group when we issued the margin call. And then when there was negotiations we knew it, we found out it was Frasers Group, and they were saying, well, can we just pledge our shares to you? And they said, well, that's going to create a direct relationship between you, Frasers Group, and us, Morgan Stanley. And we don't want to deal with you as a client or as someone who we have a direct relationship with. So that's not intending to do you harm. That's just saying we don't want to deal with you as a client. So I think that's partly why I think this stuff that came up in the trial, the kind of most press-worthy comments, was about Ashley reportedly saying that it was snobbery on behalf of Morgan Stanley. They had it in for him. And I think that was important as a legal part of the case, because they needed to show that it's actually, there was this intention to do him down, that they had to bring that in as well.
Mm-hmm. So it is fascinating sort of seeing all of this stuff, come in. And what I think you've illustrated to us brilliantly is that because of this talk and having to kind of show things, it makes some of the things that we've been flagging to people in the audit functions, really kind of raises the profile of stuff. And I'm thinking very much about, the communications internally with these forums, because this is the kind of material that someone can utilize in a case to say, I'm trying to prove that you were trying to do me harm, or you were misleading me, or whatever. And so it is certainly an area that's demonstrable of risk for people, I think, out of this case. And that's been a really, no matter at the end of the day whether the judge came to a decision or not, you've explained, I think, to all of our listeners who are sitting there in audit, why they really should be thinking about this and asking the business, have they thought about this? How are you, protecting yourselves? And what thought are you giving to this? Because clearly, this is the kind of case that just evidences why people would, have a field day with some of that stuff.
Yeah, I mean, I don't think that. I think if the judge had come to a judgment, I don't think it would have come to anything that would be startlingly changed the market practice. I think it would have said that, if you leave open the issue as to how much you can charge margin, and you've got these relationships which are in a very loose and not really tied down, that leaves it open to, have a margin call of a huge magnitude being issued against you. But so that's from a legal point of view. But on a sort of commercial point of view, it's obviously not. Although Morgan Stanley, I think, will have been quite satisfied with where they got to in the end. They de-risked the position. They got rid of Frasers Group claim. It was hard. It's not exactly an elegant solution. I mean, it was a drastic action, and they got an injunction against them. They got a trial, and there's got to be they must be thinking this has to be a better way of dealing with this.
Well, it's one of these things where you sleepwalk into these things, I think. Yeah. I think, will Morgan Stanley go there again? Probably not, because they've now, their eyes are wide open to where it could go to. And yes, all the things you're talking about, yes, it kind of ended up in an outcome in terms of there wasn't a judgment against them, but boy, have they picked up some costs along the way. Mm-hmm. I mean, all of this has generated cost at every level. Obviously injunctions costly and going to court costly, but the build up to all of this, just the discovery, going through and just finding all of this information. How many man hours was spent, poring over this? And that's a big cost and a big distractor, because I'm sure, the front office managers are sat there kind of, scratching their heads over this stuff and feeling pretty edgy, when they should be thinking about how they can make lots of money for the bank and the shareholders.
So do you think the pendulum has swung, from going from Archegos Capital, which is obviously a completely unleveraged and very risky position for the banks to be, where they didn't know what other banks were involved, etc. And they got it wrong in that sense. And then it's gone this way, and they've got actually what was probably quite a safe position and a well-protected position, as you say. And they've gone in all guns blazing. So they're probably thinking, where do we...
That's a really interesting point, Robin, because, of course, the timing of this was all tied up with Archegos. And we pointed that out in the first podcast. And also, conveniently or not, the numbers were very similar between what Morgan Stanley has purportedly lost on Archegos versus the amount of money that they asked the Frasers Group for. It was all comparable. And in, I think, the space of a couple of months, if that. I mean, it was really close in timing. So you've got to ask yourself the question, if this situation had come up now, how would they have dealt with it? Or indeed, had the Frasers Group situation come up before Archegos, how would they have dealt with it? Yeah. And I don't know what the answer to that really is, but I do think that the fact that it was so close together, and I can't blame anyone inside an organisation for being really cautious around stuff when they've just been burnt on something. That they're naturally going to do that, right? Yeah. That's human nature, and that's sensible for people. But I don't, I think you make a good observation in that this one was a very different risk profile from the Archegos situation. So, I think that's been a great sort of, what happened, a summary of what happened. Why not see this through to fruition, Robin? Is that, I don't want to, accuse Mike Ashley of being scared. And maybe that's not what happened. Was there more to it than that? What happened? Why do you think, in your judgment, they went all the way, to sitting in the court, trading blows?
I'll stick my neck out and say, I don't know.
Oh, come on.
No, I don't.
You're sitting with two traders. Come on. And you've been through the SKADI trader workshop. So come on, we're not letting you off the hook here.
No, I wouldn't expect it. Okay, so I think there are two things which occur to me. One is they didn't like the way the evidence went in the trial, and they thought we're going to lose, or they never thought their legal position was that strong, and they thought they were going to lose, so they decided, we'll back out now. They'd have had to have paid the costs, Morgan Stanley's costs up until then, but hey, maybe they just decided that was a better option. Or secondly, they were claiming, I think, 50 million in damages. Maybe those damages evaporated. I don't know. Maybe they didn't really exist. Maybe they, got better over time. So
harder to prove because the damages weren't necessarily there.
Not harder to prove, but the fact of, if actually we only lost 5 million, well, you're probably paying 5 million in legal costs.
Yeah. So it's a pragmatic kind of pull away. Yeah.
Yeah. So just in terms of, is it worth it? If they were actually claiming 50 million, they might think, well, who knows? Who knows what the judge is going to say? Let's give it a go. But if the losses are much less than that, then you might think, well, it's not really worth taking a risk. Who knows?
And is there not some other explanation? Because obviously you've laid out that this was a lot about, with the objective of getting hold of an injunction. Was that really the story? The injunction was achieved, and all of this was extra.
Well, they could have withdrawn at any point before the trial. So if they really thought they had a terrible case or were being advised of that, then they might have withdrawn before the trial. So who knows why people decide things, what advice it was given.
Yeah.
We don't know.
So that's very much sort of looking at things from House of Frasers Group point of view. So it's called the House of Frasers. What about, what was driving Morgan Stanley to fight this all the way, do you think?
My guess is they thought, well, if we accept that we didn't have the right to issue a margin call against Saxo in relation to an unknown counterparty where we didn't really know what was going on, I think they wouldn't have thought that was an acceptable precedent to be struck, and so they're risking the judge saying, at worst case scenario, the judge saying the way in which they calculated the margin call was irrational, and they had intended to cause Frasers Group loss, and so not only would they have to pay Frasers Group, let's say 50 million, if that was the right amount, plus they are, risking the judge telling them how they can carry out margin calls in the future. And I can see why they really didn't want that to happen.
Yeah, yeah. So that's why you think they were happy to kind of step out of this.
No, they didn't make the decision. It's Frasers Group who just withdrew the claim.
Right.
They just I don't believe there was a settlement.
Mm. Right. Mm-hmm.
So Morgan Stanley had nothing to do with it. Yeah.
Okay. Interesting. So out of all of this, I think what is interesting, because Damian and I were at an event recently, and we were talking to a lawyer on the cyber side as a result of the work we do in cyber. And they were discussing the fact that actually they had used subject access requests in cases similar to this to find out information. So is that something that you have experience of yourself?
Certainly we have acted for clients who had claims against banks, and those are individuals who are either directors of a company or as individuals they are customers of the bank. And you can make a subject access request to obtain information which is held in respect of any individual held by anybody else. And so you don't need to. The key advantage to that is that you don't need to have issued proceedings. So you don't have to go to all the expense of actually issuing court proceedings, which is obviously a very costly thing to do, in order to get that information, which you do for court disclosure to be ordered. So you get proceedings, and then people have to disclose everything that relates to the case to the other side.
I think you used a word there, individual.
Yes, that's right.
So that's interesting, because in this matter, if they used subject access requests, they probably were able to, because behind this, there is this individual like Mike Ashley who's likely to generate that kind of paper trail, e-com trail noise. And a bit like thinking about Mr. Farage and the debanking. Again, that's an individual that's likely to result in a lot of paper trail within an organisation.
I mean, Nigel Farage would be a classic example, because he is an individual. He can say to the bank, I want to know what information you've got on me, because I want to know whether it's accurate. And the bank has to divulge that information. Now, if it was, you're a director of a company, and you say to a bank, I do want a subject access request on the information you have, they're only obliged to provide that information as it pertains to the individual. So you're not going to get very much. You might get the odd snippet of information which actually relates to the individual themselves, but not to his company, because that's not his personal information or data relating to him. So that's the disadvantage to it, that in some circumstances it's quite limited.
So thinking about our audit customers and our people in the front office, should they be avoiding talking about individuals? So if you're dealing with the Virgin Group, don't talk about Richard Branson, talk about Virgin. Is that is that a good safeguard that people should be thinking about to protect themselves?
I think it's always good advice not to start saying or writing things about individuals that you think you don't necessarily want people to see, and certainly I've seen cases where the individual's made these requests, and you get this memo written about the individual, very rude, about saying somebody's completely mad or they're So no, it's not a sensible thing to do, to put down, especially in writing, thoughts that you might not want to broadcast outside of private conversation. But on the other hand, I think there are things which are unavoidable that you will need to, for anti-money laundering reasons.
Of course.
All those reasons for having information about, and obviously banks will have, using banks as an example, they need to have a view about a director as an individual in terms of their capabilities. Are they, how good a credit risk are they? So you can take it too far. I mean, I don't see any reason why people should avoid putting down stuff which they need to for the purpose of the business about the individual concerned, and nor should they. So, no, I wouldn't.
Well, I think it's an interesting problem because our society, really lauds these kind of rainmakers. I'm thinking about try talking about Tesla without talking about Elon Musk.
Yeah.
Try talking about Amazon without talking about Jeff Bezos. And the list can go on and on and on. It's quite unusual. I mean, these are some massive names. So I'm just sort of, I'm interested in that respect. I mean, of course, everyone's got to be open and honest and frank and own risk. But I just think there's a sort of an interesting kind of observation that, people are certainly exploiting this now as a tool.
Yeah.
And therefore, I think it's only right that people consider that and think, well, if that is the case, if these things are going to be used like a tool, then what should we be doing here? How can we guard against this or think about this, so that we aren't dragged into unnecessary procedures.
Yeah, I think as I say, if you don't need to have data on individuals, then I think people should be aware of this possibility that there are these things, these subject access requests, and that people can obtain that information. So, you can make your own choice as to how much information you retain about individuals because of that.
Well, that's fascinating. I'm trying to think, DC, is there anything else we want to
not that I can think
cover over from last time? But I think Robin's done a sterling job of taking us through the follow-up, the result. It would have been lovely to have had a judgment, which we didn't get to read. And this is in the commercial court, so the judge goes away and writes their report.
Yes.
So presumably they're pretty happy.
Well, that's right. I mean, I was talking to someone who was actually involved in the case last week, and they were saying technically that the judge could still write his judgment.
Oh, okay.
He could just, off his own initiative, decide that he wants to write a judgment. But as you say, they're quite busy And I should imagine that, for the majority of judges, for them to say, you don't actually need to write this one, he'll go, oh, thank goodness for that.
Well, and if a judge decided to do that in the commercial court, decided that this was worthy of a judgment, where does it leave two parties that have withdrawn from a case?
That's an interesting question, because I don't know the answer to that, because there are probably various options for the judge to take in terms of apart from apportioning, legal liability, how he deals with how much is going to be paid from one side to the other, I think will be difficult. I mean, in this case, so let's think it through. Frasers, they withdraw the claim. So they've withdrawn the claim. They've said, we're not claiming anything against them. So the judge could, I think, and I might be wrong about this, but I think he could say, well, this is what I think. This is what I've decided is the law. And Frasers they've already withdrawn the claim, so they don't get anything.
Fantastic.
But I might be wrong.
Well, I think with all these things, it's always the twists and turns that's really interesting. And I think, out of all of this, there's been some important takeaways for, people in the financial markets, and considering what has happened here. Always great to have a real world example. So people can pore over it and sort of say, there for the grace of God go I. There's some really good learning. So, Robin, thank you so much for that.
No, it's been a pleasure as before.
Really appreciate it. And DT, you and I'll be back, because it's nearly the month end, with another exciting edition of Horizon. Looking forward, telling people what we think is about to come over the horizon. And so until next time, thank you very much for listening and tuning in. And that was Nic and Damian with Robin Henry from Collyer Bristow. Thank you, Robin.
Thank you, Nick.
Thank you, Alexandra, for the photo.